welcome to In the Hot Seat with the Tenney Group. I'm Spencer Tenney. It's good to be with you. Today we've got a lively bunch with us. We've got Joe Harraka and Anthony Vizzoni from Becker LLC, a transportation-focused law firm. Gentlemen, welcome to the Hot Seat.
Thank you very
Thanks
much.
for having
It's a pleasure to be here, Spencer.
All righty. Well, before we heat things up, gentlemen, why don't you each just take about 20 seconds, tell us a little bit about yourself and the work that you're doing at Becker. We'll start with you, Joe.
All right, sure. I'm a senior litigation partner within the firm. I also, along with Anthony, co-chair our trucking and logistics group. I've been an attorney now, Spencer, for about 35 years, and I'm licensed in practice in New York, New Jersey, Pennsylvania, and California, all the jurisdictions in which the firm has an office.
All of which all the legal problems exist. You just you're right there. And you, Anthony.
Sure, thanks, Spencer. So I co-chair the trucking and logistics group also with Joe, and I also chair the firm's business services group. And I've been practicing law since 1991 and focus my time mainly on corporate mergers, acquisitions, and a bit of commercial real estate also.
Terrific. Well, I know that we have mixed it up a little bit at industry events, TCA, and others here recently. I'm excited for us to mix it up here in the hot seat. So let's jump right in. So, common situation in our industry, trucking logistics companies providing multiple different services. How should they go about maintaining some separation from those different services and liabilities that are tied to them?
Let me jump in. First of all, I'll just say that, as you well know, Spencer, unfortunately, the industry has suffered a significant number of recent jury awards exceeding $10 million. I mean, we all know them as nuclear verdicts, okay? And unfortunately, they're on the rise, and they're impacting to a great deal the trucking and logistics industry. And these judgments and awards often exceed, unfortunately, the insurance coverage that's available to our respective clients. And so Anthony and I have done our best from a legal standpoint and a business standpoint to try to proactively, upfront, best protect our industry clients from that exposure. Because unfortunately, as you well know, once a trucking accident of some sort arises that creates this exposure, it's hard at that point to try to address the situation. It's only by addressing it up front in a corporate structure and in advising our clients in how to best position themselves from an insurance standpoint that they're in the position to address these potential exposures.
So, Anthony, what should we be doing, or what should the companies be doing to maintain that distinction
Sure.
between?
Yep. Yeah. I mean, probably the top of the list would be the corporate formalities, right? So you don't want these plaintiffs' lawyers making alter ego arguments, or at least if they are, not being successful on them. And you want to maintain the corporate formalities of the company. A lot of these businesses may be family owned, so they're out there just doing their thing, operating on a day-to-day basis, which is fine. But to the extent that you have different divisions, sister companies within the same umbrella, under the same overhead, you want to maintain the corporate formalities. Have annual board meetings, draft resolutions, have shareholders meetings. Really, have documentation. Make sure you have the proper documentation. Maintain separate books and records. So that's important to maintain the separation of the companies.
What about one master insurance policy? Is that sufficient, or would you suggest going a different route?
Well, it really depends on the factual circumstances, the geographical location of the company, how intimate there is in crossover with respect to, for instance, we represent companies that have a trucking division, logistics division, warehouse division. And in some instances, Spencer, I'm sure as you well know, if they get a master policy, there's some buying leverage, so to speak. But in most instances, it's really the trucking aspects of the business that has the most potential for exposure and which generates the highest risk profile such that that really is the company or the division of the mothership, so to speak, that would really cost the most in premium. And so we have forged relationships, as I'm sure you have, with insurance brokers. And we obviously try to refer our clients to those insurance brokers to try to evaluate the company and take an audit of their past risk profile, their past losses, and to determine if it's really better to do a master policy or to do separate policies. Now, in some instances, it may be better to do one or the other from a primary standpoint, but when it gets to the excess level, it may be a different situation because there the excess carrier is only going to be implicated at a certain threshold, be it $5 or $10 million, and it may be a different situation for an excess carrier to underwrite a policy than a primary carrier. So it depends on a lot of different facts and a lot of different circumstances.
I think that's good, just the way that you describe that in terms of how you might even want to process going through it. But those are very interesting considerations that people should be thinking about here. What about just you have multiple entities now to provide you some limited exposure by spreading that across multiple entities. What does that necessitate buy-sell agreements now between multiple entities? I mean, what's happening there with companies that have developed all these multiple entities?
Sure, yeah. So buy and sell agreements, operating agreements, shareholders agreements, they're important documents, right? So they will certainly protect in the event that you have a catastrophic event for one of the owners, right? So, for example, if there's say there is a nuclear verdict and somehow they pierce that verdict and they get to one of the owners. And if you have a situation where there's a judgment that gets to the owner and maybe have other owners, it could be family or non-family members, you want to protect the company so that the creditor doesn't interfere with the operations of the business. So in those cases, we'll trigger buy-sell agreements. So there could be a redemption of shares. There could be an outright purchase based on some sort of formula. It could be a formula that's tied to a long-term repayment plan. So you could spread out payments over a 5-year note with interest. So those protections are always good. Also, if you have the really drastic situation where maybe an owner needs to file for bankruptcy because of a judgment. So in that case, you want to protect against any type of bankruptcy trustee coming in and having a say in the operations of the business, right? So even if there's an economic interest there, you want to be able to take out that bankruptcy trustee as quickly as possible and remove that from the operation to the company. So always good to have, really good to show independence also.
Very interesting. So I've got a couple more questions that I want to get to, but let me just kind of back up here a little bit. How did you all find yourselves providing legal expertise within transportation logistics?
So good question. So we started maybe 15 years ago or so, representing a lot of different clients who were in the trucking business, right? And my background as real estate, I was doing a lot of landlord and tenant work in commercial real estate, and we started to see a lot of opportunities develop as a result of e-commerce, right? So the big boxes, warehousing, and what was happening was we just kind of saw that people were starting to go down the e-commerce route and obviously the supply chain. And we just started getting really, really busy on the trucking side, working with port authorities. And we just thought there was an opportunity there. So we just started doing more of that work, developing more relationships, word of mouth, our clients recommending us to their colleagues in the industry. And it's worked out well for us. So here we are.
I love that. So you mentioned port authorities, and I know this is what many others may not know about you all in terms of your expertise specifically around the port authorities. What are some of the legal trends that you're seeing in that area, and how do they impact the trucking industry?
Yeah, so the one thing we're seeing here on our market is the lack of availability of real estate is having a big impact, right? I mean, the prices have gone through the roof. Space that maybe was leasing for $8,000-$10,000 an acre years ago. Now they're going for $50,000 and up, depending where you're located. If you're close to ports, close to the airports. So there's really been a huge rise in prices, and also on the trucking side, we're actually seeing some acquisitions where competitors are acquiring a target for space to be able to get space, right? So they're hoping that they can step into the shoes of a target company, acquire a company, and work out a deal where they could assume that lease and really have a long-term home based on favorable terms that there's going on in leases right now. The issue with that is that you have savvy landlords, and somebody's coming in to assume a lease, and they have any say, if they have a consent, they're going to bring the prices up to fair market value. So so really, land availability has been a big issue around us, and also the things that we've been talking about with truck drivers. We're seeing a lot of acquisitions where companies are acquiring targets just based on the fact that they have a good pool of drivers and maintaining those drivers.
Joe, what would you add? What are some of the things from your vantage point? What are some other evolving trends that you think some of our networks should probably be aware of in the legal world?
Well, I mean, the bottom line is, as Anthony has mentioned, there really has been a clamoring, so to speak, for both space and for trucking. I'll call it personnel, so to speak. And because of that, and I'm sure you're well aware of this, Spencer, your company, there's been a significant increase in mergers and acquisitions. And a lot of the things that we do as a firm is to assist our clients in looking at for potential clients or potential targets. In fact, Anthony and I, all the time, whenever anything ever comes to our attention about a potential acquisition or a potential opportunity, we'll circulate that to our clients. One of the other things that I think that will resonate with you is that we have tried our best to stay on top of the industry because there are a lot of moving parts, particularly with the pandemic. And one of the ways we've done that, and I see that your company also does it, is we stay very actively involved in our trade associations, be they local, regional, and the one where we met your company, and you in particular, the National Association of the Truckload Carriers Association. And it's important, given what's going on in the industry, to stay on top of our trends. And the way of doing that in particular is to be a very active participant in the associations, not only a participant, but a board member or an active speaker. And I know that you have, in many, many respects, done that.
So, what advice would you give to folks that are looking to acquire? I mean, we've had more first-time buyers, as you're aware of, come out of the woods in the last 24 months than ever. I mean, as part of integrating this as part of their growth strategy. What legal advice would you give to first-time acquirers as they kind of enter into this new stage of their company's development?
Sure. So due diligence, right? Due diligence, and then more due diligence. It's just important to understand where potential liabilities can hit you from, right? So successor liability claims. Um, when you're looking to acquire, if there's any hair on a deal, if there's potential claims out there, you want to understand how maybe as the buyer that you will be indemnified, right? So if something comes back to the buyer, just making sure you have the protection, right? So if you have an indemnification against a company that sold all its assets, and cash was paid, the cash has been distributed to the owners. What are you chasing in terms of, is there any teeth behind indemnification? And then the other big thing that we're focusing, if you're buying a company that has different divisions, so say you're buying a trucking company and they also have a warehouse division, start there with the separation, right? So to the extent, deal with the licensing, to the extent that you could buy separate entities through separate buyers, do that. So start that process immediately going into a transaction where you are not buying as one buyer, right? So buy through a trucking division, get licensed there, do what you need to do. Buy through a warehousing division, separate leases, all of that to kind of maintain that separation and deal with the employees, maybe put the trucking employees on a separate payroll. If there's one group of employees, maintain a shared services agreement. So yeah, just start off with the separation.
I think that's good advice there. So two more questions. The first being for those that may be hearing this and identifying in their own business that maybe I don't have enough separation between my types of services from a legal standpoint. What steps, and maybe Joe, maybe you can help us out here. What steps should they take as far as getting involved in the process to start separating those out so that they can have more options and less exposure, more ability to fight another day should they come into a little bit of a snag?
I really think it's important for them to kind of make an assessment as to how they can operate efficiently as a business, and then how they can basically conform that operation to what makes best business sense to protect not only the individual companies or the various divisions that they have, but also, let's not forget, as Anthony mentioned, we don't want a situation where a principal or principals of the company incur personal liability when up front they can basically take advantage of what the law provides for them, and that legitimately provides, and that is a separation between their business interests and their personal interests. So I really think that they need to evaluate up front. While I recognize there's some constraints with respect to what makes business sense, what's productive, and what's efficient, but they really need to really counsel with an attorney and figure out how they can best organize their businesses to both protect the various divisions within the company and, more importantly, protect themselves from personal liability. Because while they wouldn't be doing anything wrong, because the law provides them that opportunity. So I would really defer to Anthony as the best how to get that process started. But we really need to, if there's one takeaway from this hot seat, it's do that up front. Don't wait until it's too late. Don't wait until you have a potential exposure, because at that point, there's really a limit as to what you can do to protect your business and to protect your personal assets.
Well, listen, gentlemen, I really appreciate you guys taking out the time, sharing your expertise. There's, what we're talking about. It just takes one time, one episode for somebody to get themselves in a serious bind. So I really thank you for sharing your things, your insights to get out in front of some of these issues. They're not hard conceptually, but they are kind of hard to execute sometimes. And so I appreciate the encouragement to our group. That's going to do it for us in the hot seat, gentlemen. We will see you next time.